province. And if you want to put your acknowledgement in the chat, we always are interested to see that. So moving on, I'll introduce the speakers briefly. They can add to whatever they want to say about themselves, and then we'll start. So the three speakers today are Caitlin Wright. She's an advocate at TAPS and does a lot of CPP-D work there. Sohrab Rezaei is at MS Society and in working with clients there, does a lot of the same kind of work. And Ashley Silcock is a long-time advocate working in CPP-D at Disability Alliance BC. I'm sure you've probably met all of them, but if you've been done CPP-D courses before, you would have met Ashley. I'll hand it over to you. We're recording the beginning of this for sure. We're doing a lot of group work. We may not record that, but that's the plan for the day. Thanks.
Hi, my name is Caitlin Wright. Just a quick caveat. I am now in the Income Assistance Project at TAP, so I mostly help folks with provincial disability and income assistance issues and reconsiderations. I had been in our federal disability project for some time with CPP-D and some reconsideration work, sharing that work with our previous staff lawyer, Daniel Jackson, who did take most of the any reconsiderations or appeals to the Social Security Tribunal. Just wanted to acknowledge too that I live and work on the traditional unceded territories of the Lekwungen speaking peoples, known today as the Esquimalt and Songhees First Nations, as well as the surrounding territories of the WSÁNEĆ peoples. So today we'll start with a brief PowerPoint on just sort of the basic setting up for doing the group work towards the end of the session. So talking about sort of the basics, eligibility with CPP-D, getting into severity and prolongedness, how to determine MQP, known as the minimum qualifying period, and then talking about the different provisions that will be helpful to know and to understand how to apply in situations where you're maybe working with a client where their contribution history isn't quite where it needs to be in order to meet that eligibility requirement of having made valid contributions to CPP. And please, if there's any questions, just hold them until the end. It's not a very long PowerPoint, but we can answer any questions that you have then that come up. Okay. So first, just a brief sort of, it's inevitable that you get you get into that pattern of comparing the provincial and the federal disability benefits. Most of you are probably quite familiar with provincial benefits with the ministry. So I sometimes like to think of what CPP-D isn't. So it's just a straight income benefit. There's no medical coverage, no supplements, no transportation or nutritional or health supplements. It is taxable, and you can request to have tax deductions voluntarily taken off your monthly benefit, as opposed to potentially maybe owing something at the end of the year come tax time. One thing that you'll probably notice if you work with a lot of provincial ministry clients is when they go through the CPP-D recovery process, when the ministry essentially forces them to apply for their CPP-D pension, that retroactive amount that is then clawed back by the ministry can leave folks with quite a large tax bill, which is not great, especially when you are someone who's obviously living in poverty, but you can't, use that part of that lump sum to help pay for that tax bill. It's money that you don't get to keep, that the ministry obviously is clawing back. But you can request by talking to the CRA to have the tax bill split for the different years to help lower that tax bill. And also applying for the disability tax credit could also just be another way to help lower any potential taxes that you would owe. there's different reporting duties, of course. There's quite a different expectation around your ability to work compared to the provincial disability benefit, which we can talk about. And it probably, at least that I can always identify, one of the positives with CPP-D is that it's not income tested. So it does work out for folks who are potentially in relationships where their spouse or partner does make significant amount of money, but the person applying themselves is unable to work and has a real need for using this benefit. It allows them to be able to apply for it instead of taking their partner's income into account and potentially not making them eligible. The whole spouse in the house rule that the ministry still follows. So the benefit itself is just a fixed amount that changes each year due to inflation, plus about 75% of what a person's CPP contributions were over their working lifetime. So it obviously changes year to year. It also means that everyone's CPP-D benefit amount is different. So unlike with provincial benefits where you can go see those sort of standardized rate tables, there's no such equivalent really with CPP-D. For 2021, those are sort of the fixed amounts. So 51085 is that base amount that everyone who is approved for CPP-D would get. And then, up to 75% of their contributions. So often when we work with clients who potentially have struggled with health and medical issues, maybe not been able to work for substantial years, probably we all know that the terrible statistics that people living with disabilities are often underemployed or in jobs that pay quite a bit less. It's not it's fairly often that we see folks applying for CPP-D who wouldn't even reach $1,000 as their total monthly benefit. So well below what the ministry rate is right now for PWD as an example. The maximum rate right now, it is a little bit more than the current PWD, and if they hadn't increased it by 175 this year, it would be quite a substantial difference. But the maximum right now is about 1413. And then the children's benefit, which is for children of disabled CPP-D recipients. If you're under 18, that amount will typically go to, that physical money will typically just go to the parent. But if you're between the ages of 18 and 25, that amount goes towards the child of the disabled beneficiary if they are in full-time school. So contrasting that again, just with PWD, aside from that rate increase, the difference would be a lot more significant if that hadn't happened in April. So of most of the types of CPP-D income, or benefits, I should say, are considered unearned but non-exempted income under ministry regulation. The only two that are considered to not be essentially deducted from someone's PWD would be the child's benefit or orphaned child's benefit. So even if it's survivors or just regular CPP or CPP-D, unfortunately, all those are obviously deducted dollar for dollar. Okay, so now we're just getting into some of the basics of what is CPP disability and what would the criteria be. So just really quite simply, you need to have a severe and prolonged disability. And those two characteristics or factors must be simultaneous. You can't just have one. They have to be present together, be under the age of 65, meet the contributory requirements for CPP, which we'll talk about in a few minutes, and due to having a severe and prolonged physical or mental disability, be unable and prevented from regularly pursuing substantially gainful occupation. And I'll try to break down what that little last bit means in a couple of slides. I thought too that I would just put into the chat now the Canada Pension Plan Adjudication Framework, sort of as I was alluding to previously before we started, is the Service Canada or the federal government's take on providing policy or information on basically how they adjudicate these applications. So it takes what I often find to be quite limited legislative information from the actual act, and it looks at it in great detail, but what all those words would mean, what does substantially gainful mean, what does severe and prolonged mean. So I thought I would just, let me just make sure, yeah. So I just put that link in the chat. Oh, am I speaking too slow, quietly? Oh, is that?
Can you hear us when we speak, Caitlin?
Can people, okay. Have they not been able to hear me this whole time? And I've just—
Nope, you've been doing great. That's
okay.
Great.
Okay, well, I did have it down low, so I do apologize if that was the case. Okay. So let's get into what severe means. So a disability is severe if it renders a person incapable of pursuing substantially gainful occupation. So the sort of main characteristic that they look at, that the adjudicators would look at, is the medical condition or conditions themselves. So looking at the nature of the condition. Is it progressive? Is it degenerative? What are some of the functional restrictions that your client may be facing? So physical as well as cognitive and emotional. The impact of treatments is a real big one. So if there is a likelihood that treatments like medication, different therapies, counseling, or surgery, if that is likely to have a significant improvement on someone's medical condition, we often see that in denials as part of a reason why someone was denied, because there is treatment available that is open to the individual that maybe they haven't tried. So we often see that, unfortunately, as reasons for denial. Comorbidities, so if a single condition by itself isn't enough to meet the severe test, are there more conditions, two or more than that conditions present, that together cumulatively meet that severe threshold as well? Sort of similar to a lot of the case when it comes to both provincial disability is the willingness of the adjudicators to really trust and emphasize the information provided by medical professionals as the quote experts. So any direct statements that they can provide on the prognosis of their patient, of the likelihood of any improvement, is really helpful if they're willing to confirm that their patient is not. And then personal characteristics as well. So things like your age, although as Ashley has pointed out, really anyone under 65 in the eyes of the federal government is still considered young, but as well their education. So have they had lots of higher education? Have they had lots of different training? Could there be transferable skills that can transition someone from maybe not going back to their previous type of work, but to another type of work, as well as just their work history? Yeah, great point, Ashley. Really, anyone under 60 is still considered quite young, but we often know that or recognize that when someone is struggling with disabilities, that 60 can, that standard is maybe different from the ability of someone to change occupations when they're able-bodied, considered or in comparison to someone who has severe medical conditions. Prolonged. So this is only really considered after severe has been met. So severe has to be confirmed first, and then they look at, is it prolonged? So likely to be of long continuation and of indefinite duration or resulting in death, which is quite morbid. Unfortunately, what it looks at then is if there's no expected recovery, if it's a grave prognosis resulting death to be likely in the near future, then they'll just, they won't look into whether it's likely to be long continued or indefinite. They'll just take that likely to result in death and say that prolonged has been met. If it's something that, a condition that is not quite as grave, what they look at then is it likely to be long continued? Is it likely to, what is the expected duration of the medical condition? Unlike with provincial disability, which has that 2 or more years sort of test for duration, there's really no legislative time period that they provide to be able to help people understand when they apply if they would meet that threshold or not. But based on, pretty thoroughly reading through the adjudication framework, what the government has sort of decided is roughly a year or 12 months as a reasonable amount of time to be able to predict, is a person likely to improve after 12 months to the point where they could return to work? So if the answer is no, then theoretically, you hope that that means that your client has met that prolonged piece. So this is just a little blurb about the substantially gainful. So this is sort of just taken directly from the Act itself. So what it means is essentially, does, sorry, what was I looking at? Right. So describing gainful describes an occupation that provides a salary or wages equal to or greater than the maximum amount a person could receive as a disability pension. So the formula for that is they look at what the maximum monthly CPP-D benefit is, which for this year is that 1413, I think it was. The times that by 12 to get what the annual amount would be. And then they basically have that amount as what is considered substantially gainful. So while it's not the automatic kiss of death, if you have working with a client who is working at some capacity while trying to apply for CPP-D, it pretty much is an automatic denial if they're working, still having health concerns and health issues and meeting that severity part. But if they're working at a gainful amount that's over that amount, which for 2021, I calculated it, which would be about 16,963, that's pretty much an automatic denial. I think sort of similar to what we see with the provincial side of things is I think it would be hard to argue that a single person or a family can really live on $16,963 a year, considering how expensive everything from food to housing is right now.
Can I jump in on that, Caitlin?
You sure can. Please do.
Okay. What I want to say is I'm actually interested at the Social Security Tribunal level for cases where people may have earnings that are over substantially gainful, but aren't doing real work. So if you have a case where your client is being so heavily accommodated that really they're not working, but their earnings are over that amount, and they get denied at reconsideration, reach out to me. And if they're at the reconsideration level in the documents that go along with our workshop, there's a doctor's question sheet that I send out to doctors. Use that for me, please, to set me up for a tribunal. I can't guarantee the client's a win, but I'm interested to see how the tribunal is handling these cases because I have heard of them making some exceptions, but there's nothing that's been a published decision that I can access, which really makes me interested. Sorry to jump in.
No, that's really great. That's a great point. And I mean, that makes a lot of sense. It's terrible that something could come down to something as black and white as the substantially gainful piece. But as Ashley was pointing out, if there is quite a bit of accommodation or sheltered employment, it would be really interesting to see how those arguments could be made to argue that this isn't really expected to be realistic work that someone can access in just the regular job market. Thus, is it real work or is it real occupation according to their own definitions? Okay, so the minimum qualifying period, or the MQP as we like to say, just in shorthand, is the minimum amount of time a person is required to work and contribute to the CPP program during their working lifetime. So that's known as the contributory period prior to when they became disabled. There's a whole bunch of different rules depending on if you became disabled after 1999 and all these sort of different modifications over the years that they've had to make to these contribution rules. The sort of standard two that we see the most are if your client has worked for less than 25 years, and that means, and that's important to understand that they had to have worked for those 25 years and have contributed, made valid contributions to CPP during those 25 years. It's not enough that they simply had some kind of income. If they made below the minimum amount of contributions, then that year can't be counted as one of the 25 years. So if they've worked for less than 25 years and worked and contributed for less than 25 years, it's only 4 out of the last 6 years. If your client has worked for over 25 years, then they need to have contributed 3 out of the 6 years. And it's good to always note that they don't have to be consecutive years. So there can be periods where in that 6-year chunk of time, it doesn't have to be, 2010, 2011, 2012. It could be 2010, and then maybe 2011 they were sick or decided not to, they were out of the country or weren't able to find work. But then the 2013, 2014, and so on, they made the minimum contributions. So something that we see quite often is, what if my client stopped working many years ago and it's too late, so to speak, to apply? So that's where these different provisions come into effect that could potentially help increase their MQP to a more recent time period, or ignore some of their low contributory years that might make it hard for them to meet their MQP. And there's quite a few of them, so maybe about 4 or 5. Most of them are going to be related to the group work that we do, but one of them that we'll mention very briefly isn't. And that's just because that one's a gong show, and we'll get to it. Will be kind of obvious when we see it in a second. So the child rearing provision. So this is meant to help with a parent who had to stay home, basically was economically unproductive, I guess you could argue, because they were raising their children up to the age of 7 for their child. What it does is it drops or cancels those low earning years while still providing the pension credits. So it could extend their MQP, and it also protects the value of their earnings during periods of low earnings. And this is particularly helpful. We often see this for parents of many genders, but we still sometimes see this being used or utilized quite a lot by mothers or people who identify as women, being caretakers for young children. The credit splitting provision. So if your client was the lower earning spouse, like married spouse or common law, during the time that they were in a relationship. They may be able to apply for what's known as the credit split, meaning that they'll be able to share those credits with their former partner. And by sharing, what it means is basically they would both the low earning spouse and the high earning spouse would kind of add up and split for the years that the credit split is approved for. So what it can do is obviously increase the income and contributions that the lower earning spouse wasn't able to make by having the credit split approved. But it can then, if your client is the spouse who was the higher wage and income earner, it lowers potentially what they would actually end up getting in their basic CPP or CPP disability. So really depends on if your client is the higher earning spouse in a past relationship. Probably not a good idea to advise that they apply for this, because it would just reduce how much they get. This is the one that we are not going to be talking about in our fact pattern. So living or working outside of Canada. So Canada has a lot of pension sharing agreements with lots of very different countries. So we figured it wouldn't be that useful to do as a fact pattern, because it's so niche to the actual specific pension sharing agreement between Canada and whatever country it is. But theoretically, if your client did live and work in another country, they might be able to use their earnings and pension credits from working in the other country to help qualify for Canadian CPP-D benefits. And the late applicant provision. So you have enough years of CPP contributions when you became severely disabled, and you've been continuously disabled from that time up until present. So if you are someone who didn't apply for CP, isn't in the position, say right now, sorry, what am I trying to say? So it's looking at when is the most recent period of time where your client made those valid CPP contributions. Again, it's still following the 3 out of 6 or the 4 out of 6 rules as the most common. And why you look at the most recent is the closer it is that you can have their MQP to present, that period of 6 years, the higher the chances that they would have a good memory for what was happening with their medical condition, as well as potentially good medical evidence, or have a relationship with a doctor. There's lots of reasons why potentially someone didn't apply for CPP-D as soon as they became disabled, which includes maybe still trying to work part-time or to sort of suffer through. Maybe they wanted to apply for short-term disability or EI sickness, or maybe they went the provincial route by going on PWD or welfare. And it can still be really hard for folks to accept the severity of having disabilities or a medical condition that impacts their ability to be gainful. We know that that is a pretty significant part of people's identity and feelings of value, is that their ability to work and provide for themselves and their families. Oh, that's why. Oh, I didn't know I did that. Okay. So we are going to go into some fact patterns and group work. And I think we're going to start out with doing a relatively straightforward activity together to sort of show you. And it's really about